Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGinnis Cooper. In my practice, I advise Canadian and international businesses on dealing with legal issues that arise here in Canada. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. Today I'm going to be speaking about individual personal information access requests. If from Europe, you've probably heard the term data subject access requests, which is essentially the same concept. This is where an individual gets to ask a business what information they have about them, expects a copy of it, and perhaps disputes its accuracy. I remember when our federal privacy law was being phased in, and many businesses were concerned they would be inundated with personal information access requests. We haven't really seen that in practice, but the right exists, and any organization that does business in Canada needs to know about it and should be able to manage it. I'm going to start with my usual disclaimer. This is intended to be a relatively general overview of the law for educational and informational purposes only. Today, I'm only going to be talking about Canada's Personal Information Protection and Electronic Documents Act. This law includes a general rule that individuals have an access right. Like most rules, this is not absolute, and there are some exceptions, and I plan to cover many of those exceptions in this discussion. While this discussion is limited to Canada's PIPEDA, you should probably know that every single Canadian privacy law includes an access right. Most of our public sector laws are divided between freedom of information on one hand and protection of privacy on the other. In the federal public sector, we have a Privacy Act and an Access to Information Act. Many provinces also have health privacy laws, all of which include individual access rights. So though I'm talking about the federal private sector law, you should know that there can be some different details from one law to the other. If you followed any of these discussions, you'll know that PIPEDA is weird. The federal law is based on the general principles from the Canadian Standards Association Model Code for the Protection of Personal Information. In fact, this standard is appended as a schedule to the law. If you read it, you'll see that it's written as a general list of principles, not like most of our laws. The general rules are in the schedule, and the exceptions are in the body of the statute. And so the body and the schedule have to be read together. So we will be looking at Principle 9 from the CSA Model Code, and then Sections 8 through 10 of the Act. Of course, we have to start with the general rule of access. This is in Principle 9, entitled Individual Access. It says, upon request, an individual shall be informed of the existence, use, and disclosure of his or her personal information and shall be given access to that information. An individual shall be able to challenge the accuracy and completeness of the information and have it amended as appropriate. This talks about access to the information itself, but it also refers to access to information about how it's been used, and the individual also gets to challenge the accuracy and the completeness of that information. There are some sub-principles that elaborate on this. Sub-principle 9.1 says, upon request, an organization shall inform an individual whether or not the organization holds personal information about the individual. Organizations are encouraged to indicate the source of this information. The organization shall allow the individual access to this information. In addition, the organization shall provide an account of the use that has been made or is being made of this information and an account of the third parties to which it has been disclosed. The business should answer the question about whether they even have information about the individual and should be able to tell them where that information came from. They also should be able to tell the individual how that information has been used and to whom it has been disclosed. Businesses are sometimes surprised to discover that they have to keep information about their information in order to satisfy this requirement. Because a business cannot disclose personal information about somebody without their consent, and the information contained in an individual access request is pretty all-encompassing, it makes sense that the business can require the individual to prove that they are who they purport to be. It also makes sense that the individual should cooperate in helping the business identify what information may be about them. That includes, how do we know you are who you say you are? And where should we look to find information about you? Information provided in that particular context can only be used for that particular purpose. I mentioned that businesses have to keep information about their information. In Sub-Principle 9.3, individual access rights include a right to know to whom a person's personal information may have been disclosed. This sub-principle reads, in providing an account of third parties to which it has disclosed personal information about an individual, an organization should attempt to be as specific as possible. When it is not possible to provide a list of the organizations to which it has actually disclosed information about an individual, the organization shall provide a list of organizations to which it may have disclosed information about the individual. At the end of the day, organizations need to know where the data they control goes and need to be able to tell people when they ask. The timelines to respond are a good example of the difference between the very general language of the principles and some of the specifics in the statute. In Principle 9 sub 3, it says it has to be provided within a reasonable time. We'll see when we flip to Section 8 that that really means no later than 30 days in most cases. The sub-principle also says it has to be at minimal or at no cost to the individual. My general advice is to not charge people for this. While there are cases where individuals will repeatedly make requests and there's no mechanism to say no to frivolous or vexatious requests, attaching a cost may make some sense. For example, in any 12-month period, the first request is free. I think Google had the right idea when it started providing users with the ability to download their account information themselves, a self-serve individual access right. Since then, many large data-driven companies have followed suit, allowing individuals to easily access their own data for free. This sub-principle says the requested information shall be provided or made available in a form that is generally understandable. For example, if the organization uses abbreviations or codes to record information, an explanation shall be provided. This makes sense. If a person can't parse a JSON file or decipher technical abbreviations, the person really isn't able to access the information. I know of some healthcare providers who will provide a nurse or a records clerk to walk through the records with a patient who asks for it. Finally, you'll note that this doesn't go so far as to give a data portability right. We do expect this to be added when PIPEDA is updated in the coming year or so. PIPEDA contains an accuracy principle, which requires that personal information shall be as accurate, complete, and up-to-date as is necessary for the purposes for which it is to be used. The individual has the right to dispute the accuracy of any personal information the company may have, and sub-principles 9.5 and 9.6 address how this is to be dealt with. It's pretty straightforward. 9.5 says, when an individual successfully demonstrates the inaccuracy or incompleteness of personal information, the organization shall amend the information as required. Depending upon the nature of the information challenged, amendment involves correction, deletion, or addition of information. Where appropriate, the amended information shall be transmitted to third parties having access to the information in question. But what happens if the company doesn't agree that the information is inaccurate? Sub-principle 9.6 addresses this. It says, when a challenge is not resolved to the satisfaction of the individual, the substance of the unresolved challenge shall be recorded by the organization. When appropriate, the existence of the unresolved challenge shall be transmitted to third parties having access to the information in question. So those are the relevant provisions in the schedule from the CSA Model Code. Now let's turn to some of the specifics in the body of the statute itself. Subsection 1 of Section 8 of PIPEDA says that these requests have to be in writing. This can, of course, be electronic. Note that the wording says must. This implies that a request that is not in writing doesn't trigger the formalities of the Act, but of course they can still be responded to. Subsection 2 of Section 8 places an obligation on the organization to assist the individual to make a request if they say that they need help. This simply makes sense. I mentioned earlier that the general language about timing in the principles is firmed up in the body of the statute. Specifically, it says an organization shall respond to a request with due diligence and in any case not later than 30 days after the receipt of the request. This is an absolute, however. In some cases, the organization can extend the time, but has to let the individual know about the extension, the reason for it, and for their right to complain to the Privacy Commissioner. The first circumstance is if meeting the time limit would unreasonably interfere with the activities of the organization. This would be if the request is complex or would require a lot of resources, would be taken away from their usual tasks, and it would unreasonably interfere with the organization's activities. What unreasonably interferes means is unclear. In this case, the timeline can be extended for a second 30 days only. The second circumstance is if the organization needs more time to carry out consultations necessary to respond to the request. For example, some of the information may have been generated in litigation, and the organization needs to determine if the privilege exception applies and to decide whether to waive it. In this case as well, the timeline can be extended for a second 30 days. The third scenario is more open-ended and allows time to convert the personal information to an alternative format. This may be to accommodate a disability. Subsection 5 of Section 8 says that if the organization fails to respond to an access request within the timelines imposed by the Act, that is a deemed refusal, and the individual thus has the right to complain to the Privacy Commissioner. You'll recall that the principles say that access requests have to be at minimal or no cost to the individual. Subsection 6 of Section 8 says you can only charge the individual if they're advised of the approximate cost in advance and the individual tells the organization that the request is not being withdrawn. Notably, there's no other guidance on costs or whether the cost has to be reasonable. Reasonableness is likely implied. If the organization refuses an individual's request, and I'll get into the exceptions that can justify a refusal shortly, this refusal has to be in writing. It has to tell them the reasons for the refusal and to tell them that they have the right to complain to the Privacy Commissioner. It also says that the organization essentially must preserve and retain the information at issue for as long as is necessary to allow the individual to exhaust any recourse that they might have. This makes sense. If it was an unjustified refusal and the result is a recommendation from the Privacy Commissioner or an order from the court to hand it over, that would be thwarted if the information were deleted in the meantime. The Act contains a number of circumstances where access either can be refused or where it must be refused. In subsection 1 of Section 9, it says that you have to refuse to provide access if doing so would disclose personal information of a third party. If that personal information can be severed from the disclosure, however, then you must do the severing and provide the balance of the information. If the third party consents, of course, then access can be granted. Interestingly, subsection 2 allows giving access even if it would disclose third-party personal information if the individual needs the information because an individual's life, health, or security is threatened. Notably, it's not just if the applicant's life, health, or security is threatened. That's a real outlier of a scenario, and if you encounter that, get immediate advice from an experienced privacy lawyer. A second scenario where access must be refused is if the personal information that is the subject of the access request has previously been requested by law enforcement, national security, or other government agencies. If this is the case, get immediate advice from an experienced privacy lawyer. The Act sets out a whole routine of consulting with the government agency, seeking their input or direction. If they say don't disclose it, you can't disclose it. And you probably can't tell the individual why, and you also have to give notice to the Privacy Commissioner. The legislators have created a real minefield for organizations if this comes up, so proceed with caution and with good advice. Subsection 3 of Section 9 sets out a number of circumstances where an organization can choose to refuse access. It doesn't have to provide it, but it can. The first is if the information is protected by legal advice or litigation privilege. This comes up a lot because individuals often use the access right under PIPEDA as a pre-litigation discovery tool. If there's any doubt about whether this information fits into this category, seek advice. And of course, be aware that providing that information would amount to a waiver of privilege. The second is if providing access would reveal confidential commercial information. But if that information can be severed, it has to be severed, and the balance of the information must be provided to the individual. The third is if disclosing the information would reasonably be expected to threaten the life or security of another individual. As with confidential commercial information, if that information can be severed, it has to be severed, and the balance of the information must be provided. The fourth one is if the information was collected under paragraph 7.1b, which is if it was collected without the knowledge or consent of the individual in connection with an investigation related to a breach of an agreement or a contravention of the law. If you refuse on this basis, you have to notify the Privacy Commissioner and also include in the notice to the individual whatever information the Commissioner may specify to you. The fifth is if the information was generated in the course of a formal dispute resolution process. This would be in addition to the litigation privilege referred to in the first instance. The sixth scenario where access can be refused is if the information relates to an investigation under the Public Servants Disclosure Protection Act. In my experience, this rarely arises. At the end of the day, Canadians are generally not frequent users of this individual access right that they have under the Personal Information Protection and Electronic Documents Act. But businesses need to understand that this right exists and should have processes and procedures to manage it. Hopefully this has provided information on the general rules that apply to this and the exceptions to that general right of access. Thank you very much for tuning in. If you have any comments on this discussion or any suggestions for topics you'd like to see covered in the future, please leave them in the comments below. And of course, if you find this sort of content to be interesting or informative, please subscribe. You can also click the bell to be notified of new videos as they're posted. Thanks again.